All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. For those who feel comfortable doing so, you're free to remove your mask for purpose of the argument. We are here for oral argument in CV 20-0110 Takieh versus Banner Health. As you all may be aware, we record and live stream these proceedings, so when you start speaking, please give your name and the name of the client that you're representing. As you have been made aware, according to current protocol, you'll be arguing from counsel table. Your time remains the same. It's 20 minutes maximum per side, and you have the opportunity to reserve some time, although that is up to you to track it. We recognize that we have made that harder on you to do since the clock is on the podium still. You may feel free to keep a running clock for yourself. I will attempt to give you signposts, but feel free to ask or to peek over if you need as you're going to keep track of your time. Please do keep in mind we have read all of the briefing. We have reviewed the record. We spent time this morning discussing the case in conference. And with that, please feel free to proceed.
Thank you. May it please the court, counsel, Dr. Sharifi is present, and my co-counsel, Jenna Milliger. My name is Mike Goldberg, and I represent Dr. Sharifi, who comes before you today requesting that you reverse and remand the Superior Court's decision, consider Dr. Sharifi's claim for breach of contract, review his claims of procedural error under the correct standard, and consider the evidence submitted for his motion for new trial. Now, at any given moment in any hospital in Arizona, there's peer review. It happens in every hospital. The peer review is critical and important for providing the quality patient care that the hospital should. But the protections of peer review are not just for the patient, they're also for the doctor. And peer review done wrong or for the wrong reasons is just as dangerous than not doing peer review at all. We're asking today that you find that the bylaws create a contract right for Dr. Sharifi. We're asking that you direct the court to...
They're two different processes. And so the peer review process is what you seem to be wanting to be redone. Or are you saying the Superior Court needs to redo something?
Well, we want to redo both. The meat of my argument is suggesting that the peer review hearing needs to be redone.
So what did the Superior Court do that warrants a Rule 59?
The Superior Court did not consider the new evidence that we brought to it. The Superior Court said, I can't even look at that new evidence because it says that the injunction will be on the record, which we agree with. The record, you can't, it's almost like administrative review. You have to deal with the record. But even Harani acknowledged...
So I want to understand, you're saying the Rule 59 relief you seek is to have the Superior Court look at that evidence?
Correct.
Okay.
And yes, that's our argument for Rule 59. We cited cases that did not have trials that allowed Rule 59. It's not turning on whether there was an actual trial. And so yes, we are asking.
Sorry, I just want to clarify that. So the statute, the 36-44502, under subsection B, which talks about the action, says, and as I understand it, this is referring to the Superior Court's review. It says the review shall be limited to a review of the record. What is that record?
That record is what happened in the peer review and what led up to it. Correct.
But you're saying that the Superior Court's error here, the reason for the Rule 59 is that it failed to, contrary to this statute, expand the record?
No, no, because we're talking about evidence that could not have been discovered. It makes perfect sense to say that the review is going to be on the record. it doesn't make sense to say that if you discover something fundamentally unfair with the process, Rule 59 doesn't apply to your case. That's our argument.
But you're saying, you're trying to apply Rule 59 to the peer review, aren't you? You're saying that the peer review should have considered this additional evidence, but Rule 59 doesn't apply to the peer review.
No, we didn't, there wasn't a mechanism to bring it up at the peer review. We're asking this court to direct the Superior Court to review the case in a way that will end up in a new peer review, in a new hearing. We want a new hearing at the hospital. That has to happen. But the 59 is directed to the Superior Court. That's the person who was supposed to have considered the information, and that court said that it couldn't.
Is there any case, you mentioned the Harani case. How does that support your argument that the court can take in new evidence at the Superior Court level? Isn't the Superior Court acting as an appellate court, so to speak?
There's a quote from Harani, did not present any evidence that Mayberry had received information from an extrajudicial source, or was it unable to fairly evaluate the findings of fact. So Harani refers, they're saying, you didn't bring any extrajudicial source to show why there would be bias because this person had a dual role. So that's the closest you'll get in a hospital case that an appellate court referenced something outside the record. The argument would be much different if we said that there was evidence, there was medical charts or some analysis of the medical chart that we thought wasn't brought up and that the court should consider. But this is outside the record that would not be discovered within the record. If you look at Harani says that the court is supposed to look at substantive and procedural errors. And the Superior Court in this case really focused on the substantial evidence and talked about giving deference on the procedure. But the flaw in that, it's understandable in a peer review case for the Superior Court and the appellate court to say, it's not our job to look at the medicine. So the substance certainly should get deference, but the procedural defects, whether the bylaws should have been changed, whether Dr. Sharifi got a fundamental trial, there's nothing for the Superior Court to be giving deference to or to review. This is, in essence, a de novo look for the judge.
Is there any case that says that?
No, there isn't a case that says it, but other than Harani. I mean, there's no doubt that this court, in following Harani, is going to make law that has not existed in this jurisdiction. The cases that cited by the hospital predate the statute. So the Harani was, the most important part of Harani is it looked at the statute where it said, okay, you can look at substance and procedure, and then there's something about you review the record. And then the next sentence says, if there's substantial evidence, then there's no injunction, which is inconsistent. And Harani looked at that and at least gave us the opinion and the direction to say that you have to look at both, and that substance and procedure doesn't, neither one takes precedent. If nobody has a question, I'd like to reserve the rest of my time.
Yeah, I'd like a question.
Okay.
So can you boil it down to 2 or 3 of the most important procedural missteps?
Yes.
I know that there's a lot in the briefing, okay, so I apologize, but tell me what is the most important procedural misstep?
The most important procedural defect is the external reviewer change and the hearing panel change. So the bylaws in 2015, as they existed, were very clear. If there's going to be an external reviewer, it has to be in the same subspecialty. and they cannot be an economic competitor, and they can't have a relationship with Banner. The hospital, we objected when they appointed an interventional radiologist who had a financial relationship with the hospital. Instead of finding a interventional cardiologist or someone outside the hospital, where there's no evidence that that could not have been found, and common sense dictates that it could, instead they just changed the rule. And they said that, okay, it doesn't matter if you have an economic relationship with Banner, and you don't have to be in the same subspecialty. The case, we know that that's important, because in August of 2017, much after this case got started, Banner was offering Dr. Sharifi to come back on the same medicine that we're dealing with today, to come back as long as he agreed not to sue in the future for future violations, and as long as he would be willing to let his economic competitors pre-approve certain procedures. So we couldn't agree. If they wouldn't have had those procedures, those factors, we would have agreed. The only difference is that after that didn't work, someone from Banner Hospital went back in cases that were 5 or 6 years earlier, and this is another violation. And they said, oh my gosh, he material altered records. He altered records. Well, that's exactly the type of behavior that the court is supposed to monitor, because that's not peer review. That's not cases come in, something happened, we all talk about it, and we learn the mistake. That is a bad actor digging through records that are years old to find something. And we had witnesses that testified that those changes were all made contemporaneously within a few days, and they were common. We had doctors come in and say that that was done.
You have 8 minutes left.
Correctly. I'm going to reserve the rest of my, oh, you have a question?
Yeah, no.
Okay. I'm going to reserve the rest. Thank you.
Good morning, Your Honors. Andy Gordon and Catherine Hyde for Banner. And I'm going to set, because if I stand up, I can't see my notes. Let me respond primarily to the arguments made by Mr. Goldberg, and let me begin first with the Rule 59 issue. There is simply no way you can reconcile Rule 59 and its application here with the statute 36-445-02, because
Can I just
yes,
pick
yes,
on
Your Honor.
that just a little bit? Are you saying that what you're asking for is a bright line rule, that Rule 59 could never apply under this statute at the Superior Court?
After
do
40,
we have to go there?
after 40 some odd years, I'm very reluctant to ever go to a bright line. I've spent some time trying to think of situations, and I've done this kind of work for a very long time. I'm having a hard time. I suppose it's possible to somehow find something that was missing in the record below, but I can't come up with an example. I don't think we have to go that far, because here, what they were asking Judge Flores to do was consider affidavits that were clearly not part of the peer review record, which is exactly what the statute says she can't do. There's a full record below, and they, at least in the facts that are presented here, it's irreconcilable.
Okay, assume we agree with you on that. The question is, okay, do we look behind the curtain in every Rule 59 case that comes up to us and weigh it to see, wow, this was, even whether it's filed pro per or not, I mean, we see lots of Rule 59 motions that are sketchy, I'll say. We typically don't look behind the curtain, so to speak, and say, man, that was a bad motion. It really didn't have any merit. And then kick it out in jurisdiction. That's the problem I'm having on the jurisdictional side. Is it what case specific case would allow us to say flat out, no jurisdiction here?
I certainly don't know all the cases your honors look at. What we're dealing here with, however, is a very, very specific statute. And limited to the terms of this statute, there is no role, in our view, for Rule 59. Let me stay on Rule 59 for a second, even on the jurisdictional question. The court will look past 59 to see if the evidence submitted entitles someone to a new trial. I mean, courts do that all the time. And citing Mr. Goldberg's favorite case, Harani, which I think helps us on every single point, and I'll get to that more in a moment. To be successful, a plaintiff must show that any bias or predetermination of the facts is based on an extrajudicial source that results in a decision based on something other than what the decision maker learned from participating in the case. That's what he read. And it goes on to say, Harani did not present any evidence that Mayberry, the decision maker, had received information from an extrajudicial source or was unable to fairly evaluate the findings by the hearing officer and discuss the matter with other members in deciding.
But this goes to whether or not the Rule 59 motion would be successful, not whether or not it's sufficient, like valid on its face to extend the deadline, right?
Yes, I'm
Just
just
to
trying
make sure
to
that
deal
I'm
with
tracking.
Rule 59 before I go on to other matters. My point here is, I think it illustrates 2 points. One is the affidavits submitted do not in any way, and we discussed this in our briefs, in any way deal with the decision makers. It doesn't talk about the decision makers at the appellate, at the hospital level, having their decision, the result of their decision is from extrajudicial sources. There's no discussion of that. But that, to get to Judge Brown's earlier question, that presupposes that Rule 59 can look at the underlying administrative matter. It doesn't help because there's nothing that Judge Flores did, which is who Rule 59 applies to, that she did where Rule 59 would apply.
Let me ask, because in just trying to understand the jurisdictional, we have more commonly the cases where it comes up through an administrative review, gets to the limited court appeals. You've got about 14 minutes left.
Great, thank you.
It gets to the Superior Court in the lower court appeal. And generally speaking, they're only reviewing based on the record before the administrative law judge. Does Rule 59 not apply to any of those either?
I don't think so. We looked to see if we could find some cases discussing that one way or the other. And candidly, we didn't. We didn't find anything in Arizona. We didn't find anything outside of Arizona. Again, I think it would depend a great deal on the statutory basis for the This is a very unique statute. The legislature in the mid-'80s decided that if hospitals were to effectively do peer review, there had to be a number of protections in place to get the doctors to involve themselves. This is a total pain. And they're being asked to render judgment on their peers. Never a pleasant process. And so the legislature created a very restrictive statute providing only one cause of action, which is the action provided by contract. We have a couple of Court of Appeals cases saying even though the bylaws are a form of contract between the hospital and the medical staff, you do not have a traditional contract cause of action. The legislature did away with that. So
what's the purpose of our court saying that? Why would we make that? What is the significance that it's a contract?
Well, I don't know, Your Honor, because
where I'm going with this is, how can your client unilaterally change the contract and there not be any consequences? Unilaterally, I assume there's no consideration involved for you changing the contract to get, change up the bylaws for the procedure.
Yes. The notion of calling it a contract goes back to the Bach case. It's the earliest Arizona case on this, where the court just sort of says it. There's, with all deference to the court, there's not a lot of analysis after that. And that same language gets repeated in later cases. But at the same time, Banner did not unilaterally change the contract. I think this is an important point, and this is in our brief. If the bylaws are to be changed, it goes out to a vote of the entire medical staff. So in these cases, the medical staff from time to time decides to update and change, for whatever reason, the bylaws. Somehow, and the bylaws specifically permit that it will be amended, that they can be amended. Doesn't say that you are entitled, as Dr. Sharifi really seems to be arguing here, you're entitled to the bylaws that existed on the day you came into the hospital. Those bylaws get updated. So, while it may be a contract in some sense, it's not and couldn't work in a traditional contract back and forth between you and me.
So what you're saying is it's more of a community contract. In other words, we have the hospital and there are all the doctors. And it's a contract with all of the doctors, and all of the doctors have the ability to change it. Not just one, but if they vote, or medical staff, I should say. I don't know if there are others besides doctors. But if that community votes, then the contract changes.
Then the
And
bylaws.
both parties have agreed to it.
Right, because that's provided for in the bylaws.
But it's not an individual doctor's ability to change
No,
it. In other
no.
words, I think our challenge is this is not an individual contract on the doctor's side. It's a group contract.
That's right, Your Honor.
Kind of a collective bargaining, if you will.
Right, I guess so.
How would we measure whether there's a violation? I know the trial court denied the claims for breach of contract, breach of implied covenant of good faith and fair dealing. Those were dismissed, correct?
Correct,
Right.
Your Honor.
You have
Now,
9 minutes.
if, in theory, because one of the reasons, what jumps out to me is there's no right to personal damages. There's no right to damages under what the legislature said. There's a right to an injunction. Can you ever have a breach of a contract, a breach of the bylaws that would potentially lead to an injunction?
Well, yes.
I mean,
This-
obviously, if the hospital just ignored the bylaws, you
Well-
wouldn't disagree that an injunction could issue by the Superior Court saying, okay, redo this. You ignored 10 of the bylaws that are important here.
Oh, absolutely.
That's the whole point.
That's the point of the statute. I mean, the statute 44502 specifically provides for that. We've never said he's not entitled to injunctive relief.
But how do we evaluate, from what I understand, he's saying that these changes were unfair. Is that illegal? And I know that prior case laws, I think of the Bach case or one of them, talks about fair procedures.
Well,
Help me understand, are we evaluating this case
No.
for fair procedures? If not, then help me understand what we're doing, or should be doing.
the version of the statute that existed before the amendments in 1984 actually did provide for a cause of action by the doctor if it was with malice and bad faith. And this is discussed in Goodman, I think. It's in Goodman or Samaritan v. Superior Court, and also in Harani. The court then, the legislature then amended the statute and did away specifically with that, what I will call motivational issues, and created the existing cause of action, which entitles them to an injunction if there is a substantial failure, and this is really important, I want to make sure I get this in, if there is a substantial failure to follow the bylaws. If we look closely at the language in 445.02b, it says the only legal action which may be maintained based on performance or non-performance of duties and functions is an action for injunctive relief to correct an erroneous decision or procedure. So the legislature distinguishes sort of between what I would call the merits of the misconduct and procedures. And that's the first part of Harani. It then goes on to say the review, that is the review by Judge Flores in this case, shall be limited to a review of the record. If the record shows that the denial, revocation, limitation, or suspension of membership or privileges supported by substantial evidence, no injunction shall issue. The substantiality qualification in the statute applies equally to what I'll call the merits of the disciplinary action and following the bylaws. And that, of course, is what the court said in Harani at paragraph 11, where it says that the court can issue a remedy for we cannot find that the legislature granted physicians a right to action to correct an erroneous procedure and then withheld any remedy for an erroneous procedure if substantial evidence supports the decision. At that point, the court's talking about procedure, substantial evidence. And we cited a number of cases in where the courts have used an arbitrary and capricious review standard for both, which fits very well with the notion of substantial compliance. It makes no sense if there's going to be some kind of strict, every jot and tittle, as my father would have said, error. Yeah, thank you, Your Honor. And it's got to matter.
And so I had to process my thinking. We're not doing a de novo review of a law under your analysis, which would be the bylaws. Which is part of our challenge. This is the unusual situation where a private party is doing all of the review as opposed to a government body, then it comes to the Superior Court. So you're saying that we have an owe deference to and defer to them on their findings on all of it, including the bylaws, and whether they complied. Is that what you're saying?
Yes, Your Honor.
And so that I understand, the other part of the argument is they have to follow the bylaws. They have the right to change the bylaws as long as both parties agree, and both parties are the medical staff and the hospital. And as long as those two parties agreed, they could change that bylaw, and that's the bylaw that then would have to be honored. Is that what you're arguing?
Yes, Your Honor.
So even though, if we had been on the original bylaws, they would not have honored them. Because they would not have honored the original bylaws because the I forget what the title of the person, the external,
Reviewer.
reviewer had an interest, a financial interest with the hospital.
Well, let me address that for a moment. They cannot, and I'm sort of jumping topics here, but the fact that someone is a Banner employee or an employee of an entity related to Banner does not establish prejudice.
But I want to come back, it could arguably, it would meet the financial interest.
2 minutes.
Not necessarily.
Okay.
Not
Let me
necessarily.
just, for sake of argument.
Okay, all right.
Let's say, okay, that doctor had a financial interest. Your point is, once they changed the bylaws, that wasn't prohibited. They were compliant with the bylaws, they didn't violate anything.
That's correct.
In the doctor's case here.
That's correct, Your Honor.
I wasn't trying to get you to concede whether or not he had a financial
No,
interest.
no. Let me just summarize by saying the following. We have a doctor here whose privileges were revoked for practicing bad medicine, altering medical records, and bullying people. We had 3 levels of review and a 13-page minute entry from the Superior Court affirming that. The fact that he lost his privileges for those reasons is never even alluded to in the brief. The fact that they don't want to talk about that and want to spend all their time on procedural matters, I think is important. Because this is not here to protect Dr. Sharifi. This statute and these bylaws are to protect the public from doctors who shouldn't be practicing in the hospital. Unless the court has further questions, I'll stop there. Thank you, Your Honors.
Thank you. The bylaws are a contract. They are there in the corrective action section to protect Dr. Sharifi. We are asking the Superior Court, for this court to direct the Superior Court that they should take a de novo look at the procedural errors, at the bylaw errors, not at the medicine. In other states, it's
What
called.
are the specific bylaw errors, though? Is it that they changed them? Because once or are you saying they didn't follow the right procedure in making the change?
We don't, the changes were wrong. They'd never, if we.
What do you mean the changes were wrong?
Well, they were done, we think they were done improperly. But more importantly, and easier for us to, let's assume they were done properly, and this is a contract. Nobody agreed that they would be retroactive. Of course, you can't join a staff in 1999 and say, those bylaws are always going to be applied to me. Of course not. They're going to be amended from time to time. But when we have a adverse proceeding, that the bylaws are there to protect Dr. Sharifi, and we start that proceeding, and they get an external reviewer, and they appoint a hearing panel, and we object all along. And we didn't make those bylaws. The hospital felt it was a problem if you were a financial interest. We didn't make that up. The hospital said you have to be in the same subspecialty. That had been there for a long time. How can it apply retroactively to Dr. Sharifi, and how could it be fair? And that's a word that is important, because you're also, we would ask that you instruct the court to look at fundamental fairness, because that's mentioned in other cases, because you can follow the bylaws and not allow Dr. Sharifi to testify, and not allow, which is a bylaw violation. He has the absolute right to testify and the absolute right to cross-examine a witness. It's in the bylaws.
And you're saying he was deprived of those?
I am. He was
He had
deprived.
no ability to cross-examine witnesses?
He had ability to cross-examine witnesses, yes, but not to do a complete cross-examination of the expert witness, and not to testify. This is the combination of bylaw violation and fundamental fairness. It's to make an arbitrary time limit, that we never agreed to, that we said for months we can't agree to. There's been no reason that it had to be that
5 minutes.
limited amount of time. And then to say, okay, we're not going to let Dr. Sharifi testify, that violates the bylaws and that violates fundamental.
How does it, do the bylaws spell out that you'll have a certain amount of time to try a case? I mean, don't judges in Superior Court all impose time limits all the time?
They
in
do.
cases?
There's no time limit in the bylaws, right?
So why was that the tribunals in their prerogative to set a reasonable time limit? You're saying that was just completely unreasonable, that he had no time to put on any defense?
No, we had time. It's absolutely unfair, absolutely arbitrary. There's no basis in fact or law to do it. There's no experience that anyone that does these matters would say that they have to take a certain amount of time. Some of them take a little amount of time. Some of them can take days and days and days and go on for a much longer time. There's no reason that the hearing officer made that determination. We also had a problem with the way the hearing officer was appointed, which is a bylaw violation.
What was the violation of the bylaws in the appointment process?
For the hearing panel?
Yeah, you said that you had a problem with how they were.
Oh, for the hearing panel. So the hearing panel, the bylaws had said for a long time, if you're going to have one of these hearings, you cannot have people appointing the hearing panel that have a bias or that have a pre-knowledge of this. And so in most cases, this medical executive committee, not everyone is involved in that. Here it was. And so the bylaws say you can't appoint the hearing panel if you have that bias. And we pointed that out. And the Healthcare Quality Improvement Act, which is a federal law that deals with these things, they have a solution. You have an arbitrator or everyone picks it. The law has thought about this problem. We brought that to their attention. It was rejected. The hearing officer said, appoint someone new onto the MEC, someone that doesn't know anything about this case. We still said, well, that person would be tainted. That's not really right. They didn't do that, though. All they did was they say, okay, we're going to take an eraser and we're going to take out the part where it says that you can't be biased, and we're going to say you can be, or it doesn't matter. And so the same people made that appointment.
And so they changed the bylaws according to their procedures. So I don't understand. I mean, I guess my problem is they have a right. I mean, the bylaws provide to change, and they changed it, and it wasn't just the hospital changing it. It was also the other medical providers. It was two sides agreed to this.
They didn't.
So
agree,
that's not a violation.
But they didn't agree to it being applied retroactively. The bylaws are not. The bylaws are in every hospital in America. They're there because the federal government requires it to get accredited, and certain things have to be there to protect the doctor. And so, bylaws can be amended. Things change, laws change. But to say, I'm going to change the rules in the middle of this adversarial proceeding, you can't find that anywhere. That's what we're saying is wrong. Those are two main issues of why it's wrong. And the important thing, and the reason
And
why...
I'll just ask, is there any case that says they can't change the bylaws in the middle of a proceeding?
That it's not fundamentally fair.
Is there any case that says...
No.
I mean, any case, because this has been going, this isn't a new statute, as we're well aware. It's over 30 years old. Or at least, if not over, I think it is over. It's close. Is there any case that has said you can't change the bylaws once a proceeding starts?
No. As far as I can tell, the most recent case that even comes close is from
You have 1 minute.
2005. Harani is my favorite case. That's one thing I could agree with on the other side. That is the one bright spot in appellate law in Arizona about how these cases should go. If it wasn't for Harani, everything that Banner would say could possibly be true, where you just look at substantial evidence. But Harani broke the statute apart and looked at each sentence and made sense out of it. And so we want you to direct the court that she can have all the deference she wants, as any court should, on the medicine. It's not our job to talk about the medicine or to retry it. I would like to, and he was great on the medicine, but that's not what the court is here for. The court is here, and the Superior Court is to decide whether the bylaws were been violated and whether there was fundamental fairness. And this judge, it didn't send the case up saying, she sent the case up saying, I can't make that decision that simply. It's not about arbitrary and capricious. That's not in the law. None of that is in that specific law.
Your time has run.
Thank you.
Thank you, counsel, for your arguments. Take the matter under advisement and issue a decision in due course. The court will stand in recess to reset for the next argument.
Good job, Andy. Good job.
Thank you. You too much.